Welcome to Employees First Advocates, BA California Employee Advocates Terms and Conditions. If you are viewing this recording, it means you have taken the first step in trying to receive justice by filing an illegal claim against your employer. This video is not intended to serve as legal advice. Additionally, this video will merely highlight a few key aspects in this document. You are still responsible for viewing this document in its entirety. The main purpose of this document is to 1. Allow CEA to share your information with the attorney, and 2. Allow CEA to fund your case on a contingency basis, which means no out-of-pocket cost to you if your case loses. However, when you win, CEA will receive 24% of the settlement for taking on the financial risks of taking the case. And 3. This is a walkaway deal. If you decide to change your mind and not pursue litigation or not retain counsel, then you walk away. If, after your free consultation with an attorney, and it is determined there are no merits for your claim, then this agreement will become void. Now let's hear from our HR representative, Hamidi, to discuss what's in the document.
This section highlights 3 key points. 1. That you, the plaintiff, are entering into an agreement with Employees First Advocates to fund your case on a specified date. 2. That you are alleging one or more legal claims against the defendant, your employer or former employer. And 3. That EFA and you have agreed to funding amount as discussed later in this document. The specifics we'll get into a little bit later. There are a number of definitions that will not be covered in this recording, but you are encouraged to review. However, some key ones are the ones highlighted below. Engagement. That's the engagement agreement is agreement to engage with the attorney. The litigation counsel is any attorney assigned to represent you in this case, either those listed before or others that are added on at a later date. Litigation proceeds. The proceeds are any proceeds received from litigating this case. This is the total value of the award prior to any deductions, such as taxes, in the event of any counterclaims, or any fees and expenses related to litigation or attempts to collect these proceeds. Another important consideration is funding. EFA shall, within 20 days of written request from plaintiff, provided any such request received on or before the expiration date stated in Appendix A, pay to plaintiff or the litigation counsel such amounts as plaintiff shall reasonably request up to the litigation fund amount to satisfy actual documented litigation costs, expenses including attorney's fees, expert witness fees, consulting fees, and disbursements incurred by plaintiff or reasonably anticipated to be incurred by plaintiff within the next 20 business days in connection with any proceedings involving this litigation. Additionally, funding is only for matters related to the case. EFA can withdraw its funding obligation for any material adverse effect, such as fraud, changes in law, or lack of cooperation between you and/or legal counsel, by which you shall still be responsible for fulfilling your agreement if you receive any proceeds. Distribution of funds. All proceeds shall go to a trust account. If any proceeds are paid directly to plaintiff, then those funds must be immediately placed in a trust. EFA is to be paid within 3 days of funds being received. If plaintiff defaults in the timely payment, interest shall accrue at 18% a year or highest rate allowed by law until full payment is received, accruing daily and compounding interest. By entering into this agreement, there are certain representations and warranties that you are making. Plaintiff has the power and authority to enter into this agreement, that there are no actions pending or to the knowledge of plaintiff threatened against plaintiff that may adversely affect plaintiff, the litigation, the proceeds, and other assets. Plaintiff is the sole legal and beneficiary owner of and has good title to the litigation. Plaintiff has not received any payments or other distributions in connection with this litigation, and that you have sole control of the litigation and any settlement decisions related thereunto and will not delegate such control to anyone else. This agreement shall remain in effect until the final resolution of all litigation, final non-appealable judgment of a court, written settlement agreement, disbursements of full litigation proceeds, and EFA receiving all funds due. This agreement constitutes the entire agreement between the parties. Plaintiff will maintain complete control of the litigation and any settlement decisions. Parties agree the existence of this agreement and the terms shall be held in strictest confidence, unless both parties agree in writing to disclose certain information or as otherwise required by law. Plaintiff and EFA shall bear their own expenses in connection with the negotiation, preparation, and execution and delivery of this agreement. If there are any disputes, this agreement shall be governed by and construed in accordance with the laws of the state of California without regard to principles of conflicts of laws. The arbitration shall be administered by the American Arbitration Association under its commercial dispute resolution procedures, which are in effect at the time of arbitration. Arbitration shall take place in San Francisco, California. The agreement shall not be modified, amended, or supplemented except by written agreements signed by the parties.
Thank you for following along with our HR representative, Hamidi. California Employee Advocates is for the people, and we look forward to getting justice for you.